So welcome back to the Essential GovCon Brief from Gordon Reese. I'm Patrick Burns, and I'm here with my co-host, Quyen Dang from our Government Contracts Practice Group.
Hey everyone, thanks so much for joining us today.
So today we're talking about 3 June developments that all tie back to competition and small business participation in federal contracting. So what we're going to cover today, what Congress is doing with the Rule of Two and why that matters for your capture strategy. A Court of Federal Claims decision in Maven that shows how hard it is to recover proposal preparation costs even after a protest win. And another Court of Federal Claims decision, primary health care, that has big implications for mentor-protégé joint ventures and small business size eligibility.
So whether you're a small business, a large prime teaming with smalls, or you basically live in the bid protest world, all three of these are worth paying attention to.
All right, so let's start on the Hill with the Rule of Two. Quinn, the Rule of Two is one of those phrases we throw around so frequently that sometimes the definition gets lost. So can you give us a quick refresher on what that is?
Yeah, sure. So the rule of two basically says this. If the contracting officer reasonably expects at least two responsible small businesses to submit offers at fair market prices, then the procurement should get set aside for small business rather than competed full and open. And honestly, it's the backbone of a huge amount of small business work out there.
So right now, that concept mostly lives in the FAR, Federal Acquisition Regulation, and in case law. And it doesn't operate exactly the same way in every context because of that. So what's new here is that Congress is moving a bill that would codify the Rule of Two in a statute. So it's not just a regulatory and judicial creature anymore, or it wouldn't be. It'd be an explicit congressional mandate.
Yeah, and that matters because once it's actually written into the statute, a couple things happen. So it gets harder for agencies to work around, and it gets easier for small business protesters to point to when they argue requirements should have been set aside.
Exactly. And all of this is happening while agencies are juggling 8A, HubZone, SDBOSB, BOSB, and bigger policy pushes like consolidation and category management. So let's talk about what this could mean on the ground. From the agency's perspective, what changes if the Rule of Two is codified?
Yeah, I think the big one is market research. Contracting officers are going to need to show a real effort to identify capable small businesses and also explain with documentation why they didn't set something aside if the record shows multiple qualified smalls.
For large businesses, this probably feels like some work that's currently full and open may move into set aside territory if the small business bench is deep enough.
Right. And for small businesses, this is a real opportunity, but really only if you can actually show up and respond to things like RFIs, sources saw notices, and capability questionnaires. Because if those responses don't come in, then the government can just conclude that there aren't two responsible smalls who qualify. And then it doesn't really have to set anything aside.
And as we stress to clients that when you see a sources sought notice, that think that this is the chance to prove that there are at least two businesses that can perform the services or supply the goods or what have you that the government is looking for.
Yeah. And then from the bid protest angle, having the rule of two sitting there, like right there in the statute, gives small businesses a much cleaner legal hook to challenge an agency's decision to go full and open.
So a few action items here. The first for small businesses, treat pre-solicitation engagement as critical. Those responses are building the record that either supports or undercuts the Rule of Two. For large businesses, start identifying which programs could realistically be carved out for small business set-asides if Congress ratifies it. So we'll track the bill and talk specifics once the statutory language settles. But for now, the story is the Rule of Two is likely moving from background principle to front and center policy. So now let's turn to the Court of Federal Claims and talk about money, specifically proposal costs. So the first case we're going to review today is Maven Incorporated versus United States. And this is a case of protester prevailed, but now the question is, does the protester get the money back? So Quinn, walk us through the setup of this case.
Sure. So in this case, Maven was competing on the Army C-3 procurement, and that one was a women-owned small business set-aside. Here, the Army canceled that set-aside. Maven then protested at the Court of Federal Claims, and the court agreed with Maven, holding that the cancellation lacked a rational basis. The court then ordered the procurement reinstated and enjoined the unlawful cancellation. So right out of the gate, that's a really solid win for Maven.
So then Maven went back to the court and asked for bid preparation costs, and that's where the court disagreed.
Yeah. So here the court reached for the familiar REMA test for getting proposal costs back. And if I boil it down, a protester for that test basically has to show three things. First, that the agency committed prejudicial error in the procurement. Second, that that error caused the protester to incur unnecessary proposal costs, costs that became a needless expense. And third, that the costs were reasonable and allocable to that procurement. In this case, the court had already held there was a prejudicial error in the cancellation, and the government didn't really dispute that the costs were reasonable and allocable. So really what the sticking point was element two.
Right. And so for Maven, it's certainly a long and painful procurement. It had to revise the proposal multiple times, filed 3 protests, and to Maven, that it felt that should be enough to recoup its costs, but the court disagreed with that.
Yeah, what the court really wanted to see was a clear direct line between sort of two things. First, the specific error that the court actually found, which was the unlawful irrational cancellation. And second, the specific proposal work that was induced by that error and turned into a wasted expense. So the kind of example the court had in mind was something like, being forced to put together a brand new or heavily revised proposal that then becomes useless once the government fixes the defect or restarts the competition.
And instead, Maven pointed to the whole saga, the flawed evaluations, multiple corrections, multiple protests, without tying any particular version of its proposal to that cancellation error in a way that made that work needless.
Yeah, and then on top of all that, Maven essentially tried to fold in the cost of its third protest. And here the court is pretty blunt. Under the applicable statute, bid protest litigation costs just aren't recoverable as protest costs. Congress capped the money relief at bid and proposal costs, not attorney's fees and protest expenses.
So for folks listening who are thinking, well, hey, if I win at the Court of Federal Claims, then what should the takeaway be here?
I would boil it down to three things. First, even if you win the protest, the proposal costs are still a high bar. Don't assume they're automatic. And second, if you think you might want to seek proposal costs, start building that record early. I would track which proposal iterations are tied to specific government actions, and then I'd be ready to show how the error the court actually finds turn those efforts into wasted work. And finally, I would suggest just being realistic. Injunctive relief, like correcting the procurement, is your primary remedy, right? Proposal costs are something you might be able to justify in certain fact patterns, but not something to budget around.
Exactly. Think of proposal costs as a potential remedy in narrow circumstances and not the main remedy. So let's move on to our third topic, small business size and mentor-protégé joint ventures. This case is Primary Healthcare LLC versus United States, decided a couple weeks ago on May 28th. This one is squarely about SBA size rules and the mentor-protégé JV structure. So Quinn, can you walk us through the facts of this case?
Sure. So here's how it played out. Primary Healthcare LLC, doing business as Anglin Distinctive Healthcare JV LLC, is a large business, but within that, Anglin is a small business. They entered into an SBA-approved mentor-protégé agreement, and they formed a joint venture and self-certified as a small business for Defense Health Agency small business set-aside. But at the time of the initial offer, including price, the mentor-protégé agreement was valid, and Anglin met the size standard. So at that point, they looked like a textbook mentor-protégé JV, taking advantage of the size exception.
But then the plot twist, right?
Yeah, right after that initial offer, things started to unravel. Distinctive told SBA it wanted to terminate the mentor-protégé agreement. Anglin eventually withdrew from the joint venture, but despite all of that, the JV stayed in the competition and submitted final proposal revisions. Competitors filed a size protest, and the SBA's area office and then the SBA OHA found the JV, quote unquote, other than small. The JV then went to the Court of Federal Claims and said, under the snapshot in time rule, size is locked in the initial offer. We were properly a mentor-protégé JV then, so what happened later shouldn't matter.
And the court certainly was not in agreement on that interpretation, right?
Exactly. The court landed on a couple of things. First, the JV did have standing. It was an apparently successful offer that would have been awarded a contract if it had been found small. But on the merits, the SBA's interpretation of its regulations was reasonable and not arbitrary or capricious. And under the current SBA regulations, the SBA has to evaluate mentor-protégé JVs as of the final proposal revision date. And what that means is actually checking two things. First, you need to check whether there is still an SBA-approved mentor-protégé relationship. And second, whether the protege is still in the picture and doing at least 40% of the work as required. And once that mentor-protégé agreement is gone, there's just no protege left for those rules to grab onto. And so you can't meet the JV requirements anymore.
So the court also addressed some older SBA OHA decisions where JVs got to, quote unquote, ride their initial mentor-protégé status even after the agreement expired, right?
Yeah, they did. But the problem is those older decisions are built on the pre-2020 regulations. But the SBA did overhaul the whole mentor-protégé program back in 2020. And the rules now look specifically for final proposal revisions for JV compliance. So the court said, in essence, there's a different regulatory framework, so you're going to get a different answer.
So the bottom line here, because the mentor protege agreement was no longer in effect by the time of the final proposal revisions, the JV could not rely on the mentor protege size exception and was ineligible for the award. So what's the message here for our listeners?
If you're a mentor protege JV, a few things. First, you should treat the mentor protege agreement as something that has to be alive through final proposal revisions, not just that initial offer. And then before you terminate or let an agreement expire, check whether the JV is in the middle of any competitions where it's relying on that structure to be considered small. For long procurements, keep a simple calendar for things like mentor protege terms, renewal dates, and expected proposal and FPR dates that should be, and those should all be on the same radar. For primes and subs more generally, a snapshot in time rule still exists for size, but the primary healthcare case shows that it doesn't prevent SBA from looking at continued compliance with JV and mentor protege requirements at the final proposal stage. So if you're structuring complex JVs, just think about what happens if the relationship changes mid procurement.
So this is another reminder that these aren't just paper structures. SBA and the courts certainly expect a mentor protege relationship and the JV terms to stay aligned with regulations throughout the acquisition. So, quickly recap June's headlines on the policy front. Congress is pushing to codify the Rule of Two, which could strengthen small business set aside arguments and change how agencies approach market research. In Maven, the court reinforced that proposal preparation costs are hard to recover, even for a successful protester, unless you can tie specific wasted proposal work directly to the error the court actually found. And lastly, in primary healthcare, the court confirmed that mentor protege JVs must still qualify at final proposal revisions, not just at initial offer, to be treated as small.
If any of this is hitting a little close to home, like maybe you're a mentor protege JV right now, where you're weighing a protest and proposal costs are on your mind, you should talk to your counselor early. The details really do matter in these cases, as we've seen.
I agree completely. So, Quinn, thank you for joining me.
Yeah, and thanks, Patrick. Thanks again for everyone listening in.
This has been the Essential GovCon Brief with me, Patrick Burns and Quyen Dang. You can find this and prior episodes on Spotify and YouTube. Until next time, stay informed and stay competitive in the federal marketplace. Thank you.
Thanks.